Hi, lovies, just me. So the second motion in limine that was discussed today, March 25th, 2025, was the hot button item contested by many. Even if you're pro-Commonwealth, you kind of clutched your pearls and clenched your butts over this one. The request for attorney-client privileged information between Karen Reed and David Yannetti, who I am a non-consensual intern of. Hank Brennan made the argument that Karen Reed had discussed and claimed that what if she had run over his foot, or what if she had clipped him at the knee? David Yannetti said back to her, well, bitch, then you have culpability here. Now, this is all before the tipster came, Steve Scanlon, and said, hey, bitch, we think that John got beat up in that house. But here is the crux. I don't give a shit that Karen said, what if I did this? As she's trying to work through something that she is like, are you fucking kidding me? I just came upon the worst sight I've ever seen in my entire life. I'm traumatized. I dropped my basket, had to go to the hospital for a section 12, and my boyfriend has passed away. I need a minute, okay? But the facts are the facts. What someone says isn't data, isn't science. And let's be perfectly clear. Officer John O'Keefe's autopsy did not reveal any injury to Officer John O'Keefe's foot, nor his knee. There was nothing. He had blunt force trauma to the back of his cranium, 2.5 inches and horizontal, that hit him so hard that you can see dura mater of his brain. He has those abrasions on his right upper extremity. But babes, he has not a bruise, not a broken bone, or any scratch. Nothing. From his neck down, other than that arm. Saying, what if I did this? Well, babe, I'm going to tell you, Officer John O'Keefe told us you didn't do that. His body told us that did not occur. I hope that the defense uses that and says, okay, she might have said this, but anatomy and physiology and an autopsy conclude this has never made sense with a motor vehicle accident. What do we see right here? Judge Bev, full of baloney cannoni. She is sitting there. She does not wear those hoops, okay, which I would like her to. But does she love her claw? Yes. She is looking very Simpson-esque. And we all know that she needs to be knee-deep in clams down the Cape by July 1st. That's why she's pushing for April 1st so hard. Brennan gets up, talks all the shit. Attorney Robert Alessi for the defense gets up. And my teacher, my sensei, my guru starts bringing out case law, starts saying it's a canonized event, that the attorney-client privilege should be in question in the Commonwealth of Massachusetts. And then Bev says, yeah, I'm not giving it to you, Hank Brennan. I'm denying it. From the bench. If you were with me in trial 1, you know that Judge Cannoni rules nothing from the bench, but she ruled this one. So, Hank, I got something in my pocket for you today. Don't spend it all in one place. I'm gonna play the clips now. Tell me your thoughts. Love your face. I'll talk to you soon. Bye.
She was asked the question by Ms. Voss, you never said, did I hit him? I hit him. And the answer by Ms. Reed was, I said, did I hit him? Question mark. And then, when I talked to David, now this is later, David said, Karen, if you incapacitated him in any way, there's culpability there. And I thought, all right, maybe I said to my mother, just to go forward for a second, they were asking me, what was it like? Did they come out? What was the house like? Similarly, in the documentary series, Ms. Reed is video and audio taped, and it was presented on television, that she said, and then when I hired David Yannetti, I asked him those questions the night of January 29th, like, David, what if I ran his foot over, or what if I clipped him in the knee, and he passed out or went to care for himself, and he threw up or passed out, and David said, yeah, then you have some element of culpability. So that's how I thought about it for about 3 days. And so that is where I get the time period regarding these relevant statements, admissions by the defendant about her state of mind and her interaction with John O'Keefe and her vehicle. These statements were made during conversations that are obviously no longer protected or private or privileged. They're no longer confidential because they've been intentionally disseminated to the public. And so the defendant has voluntarily waived that privilege.
Death would in many instances, we fear, so deter the client from telling all as to seriously impair the attorney's ability to function effectively. We think that the potential is inconsistent with the traditional value our society has assigned. Here's a key point. In the interests of justice, and that's the rooting of the interest of justice analysis, to the right to counsel and to an effective attorney-client relationship. Therefore, except where mandated by constitutional considerations, and it cites Commonwealth v. Goldman, Super 395 Mass at 502, which are not a factor in this case, nor are they a factor in not a factor in that case, we conclude that the attorney-client privilege should not yield either before or after the client's death to society's interest as legitimate as we recognize that interest in obtaining every man's evidence. So the case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to just stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for my so your motion is denied.